Welcome to topic 5.4. What does the Supreme Court of the United States actually do? Now, you'll notice here that I use the term SCOTUS. That's just short for Supreme Court of the United States. By the end of these notes, you should be able to describe how the Supreme Court actually works. So first things first, let's talk about jurisdiction. Jurisdiction means the right to make a decision. Courts have two types of jurisdiction. The first is original jurisdiction. This means the right to be the first to make a decision regarding if a law was broken or not. The Supreme Court has original jurisdiction in only a very few specific situations. In most cases, the Supreme Court cannot be the first to hear a case. They only have the second type of jurisdiction in most situations. Original jurisdiction is mostly handled in what we call district courts. These are the courts that you normally think of when you think of courts. These are where the lawyers present the evidence, there's witnesses, and guilt and innocence is decided. So this happens at the district court level. That's where they have to hear the case first, and then if you don't think the decision was made properly, the rules weren't followed, then you take it to the appellate courts, as we talked about in a previous notes video. Those higher courts have what's known as appellate jurisdiction. This is the right to decide if the law was followed properly by the government itself. So if you don't like the decision at the district courts, you think they violated your rights, that the rules weren't followed, then you take it to the Court of Appeals, and they get to decide if the district court followed the rules properly. Then above the Court of Appeals is the Supreme Court, which also has appellate jurisdiction over pretty much all lower court cases. Now, this isn't 100% true, there's exceptions to all this, but we're not getting into that level of detail in this course. Appellate jurisdiction is not about deciding guilt or innocence, it's about deciding were the rules followed properly? Was the evidence against you gathered properly? Were the witnesses testifying against you? Did they do it properly? Were you allowed a chance to defend yourself with a lawyer? Were you allowed a chance to have evidence to support your side of the argument? All that is decided by the Court of Appeals and the Supreme Court, who also decides, was that law actually a violation of the Constitution, in which case you shouldn't have been arrested for it because it should never have been a law in the first place. Now, don't worry, I'm not going to get too into detail. I'm not going to require you in this class to know the only times the Supreme Court has original jurisdiction. Instead, or when it doesn't have appellate jurisdiction. Instead, you should just know the difference between original jurisdiction and appellate jurisdiction, and know that the Supreme Court mostly has appellate jurisdiction. That's about as complex as you're going to need to get for this. Some of the things they're deciding is, did the police illegally gather evidence by violating the Fourth Amendment? Did they illegally get you to confess by questioning you after you asked for a lawyer? Did Congress have the power to create this law in the first place? Remember, we have a limited government. This means Congress can only make laws about things the Constitution says it can make laws about. And if they made a law about something they're not allowed to, well then they're not allowed to punish you for the violation of it because it shouldn't have been a law in the first place. Okay, so why is all this important? Fantastic question. Let's talk about that. This is because courts don't just determine guilt or innocence. They're also supposed to make sure the other branches are not violating the Constitution. Because remember, again, we have rule of law. No one, not even the government itself, is supposed to be above the law. In this case, the Constitution. So maybe you have another question. Why can the Supreme Court do these things? Why not other branches? Fun fact, the Constitution doesn't actually even authorize the Supreme Court to interpret what the Constitution says. It's actually not in the Constitution. Instead, there was a famous case in 1803 called Marbury v. Madison, where the court decided some things, and in this decision, they basically claimed the power to be the final decider of what the Constitution means, and no one really called them on this, and it's just kind of worked that way for the last 200 years. Now, the Constitution does give it original jurisdiction in specific cases, but again, we're not going to make you memorize those types of cases. But Congress gets to decide when the Supreme Court has appellate jurisdiction and when it does not have appellate jurisdiction. So this is one of those checks Congress has on the Supreme Court. They can actually shrink the jurisdiction, the types of cases the Supreme Court is allowed to make appellate decisions about. Another great question. How do you even become a member of the Supreme Court? Well, there actually aren't any constitutional qualifications. The Constitution says nothing about who is qualified to be a Supreme Court justice and who is not. There's no minimum age, there's no minimum education level, you don't have to be a lawyer. Nothing. The Constitution is completely silent on this. Instead, it's up to presidents to appoint justices when there's an opening on the Supreme Court. Presidents are supposed to decide who they think is best to sit in that position and make these judgments. However, they can only appoint a new justice if a current justice dies, retires, or is impeached and removed from the Supreme Court. That last one rarely happens, and usually they either die while still serving, not literally while they're on the bench here in cases, but dying as a Supreme Court justice, or they get so old they decide they just can't do it anymore, or they'd rather spend more time with their families and they retire. They can also appoint justices if Congress decides to increase the number of justices on the Supreme Court. However, while the president gets to pick whoever they want, the Senate has to approve that appointment. Once the Senate approves it, though, they serve in that position until they either die, retire, or again are impeached and removed. So while there are no qualifications in the Constitution for being a member of the Supreme Court, generally the belief was the president would pick someone well qualified, and if they didn't, the Senate would not approve them. So how does the Supreme Court do its job? Well, the first thing we have to address here is something called the legitimacy problem. To be legitimate means that it's believed that you have the lawful right to exercise government power over us. If the court is seen as legitimate, that means we trust their decisions even in controversial or unpopular decisions, because we say, well, we may not agree with that decision, but we believe that they were legitimately using government power. For instance, many people would see Congress and the president as legitimate because they are elected officials. They can wield power over us because we voted for them and said, yes, you can have this power. Justices, on the other hand, have a legitimacy problem because they're not elected and they serve for life. So they need to find another way to justify their power to us as legitimate. How do they go about doing this? That's a good question. The first thing he has to do is create trust among the public. They have to show us that we can trust them, that they're not being political, they're not being partisan, they're just interpreting the law. Now, the problem here is you're seeing the trust in the Supreme Court, which used to be in the 70s or 80s, has fallen to an all-time low, with only about 23% of Democrats trusting the Supreme Court and only 56% of Republicans trusting the Supreme Court. Independents, people who are in neither party, that trust is down to 40% as well. So you're seeing not a lot of people trust the court anymore. But they create this trust by creating self-limits on what they can do, because it needs the other branches to go along with it, right? They can make a decision, but they don't have a military to enforce that decision. They don't control the budget like Congress, so they can't appropriate funds to carry out the decision. So they limit their decisions in ways that are going to keep the other two branches, maybe they upset them sometimes, but for the most part keeps them happy so that they can work together. They also only take certain types of cases and avoid others because they don't want to be seen as political. So they'll only take questions that are about the law, not questions about politics. This is, does this violate a law, and not, should this be a law? It then has to build stability and predictability with its decisions. They do this by using past decisions to justify new decisions on similar questions. This is a concept known as precedent, not president, precedent. Essentially, it just means that if the facts of a new case are very similar to an old case, just because there are new justices on the court doesn't mean they're going to decide differently. They're going to say, well, the law meant this 20 years ago when that case came up before us, and now these facts are very similar in this new case, so we're going to decide in the same way to create predictability. In this way, you don't have to guess what is and is not constitutional because the Supreme Court already decided the issue in a previous case. So, we can always kind of know what is and is not constitutional. So how do they get over the legitimacy problem? Well, they create predictability. That predictability leads to trust, which then leads to legitimacy in the eyes of the people. At least in theory, that's how it used to work. Now, the court can overturn precedent. That is, just because the facts of a case are very similar to a previous case doesn't mean they have to decide the same way. This is called overturning precedent. However, if they do that, it makes the court look more political than legal, and that can hurt its legitimacy. So the court tends not to overturn precedent too often, although they've been doing it more so recently. The idea here is that if unelected courts that serve for lifetime appointments appear political, well, then it loses legitimacy in the eyes of the public. This means that political opponents in the other branches may refuse to enforce the court's decisions. And this means the court would lose all power in our government, and the whole thing would come crumbling down. It's a pretty dangerous game. Now, every year, thousands of cases are appealed to the Supreme Court, but they don't have to hear all the cases. In fact, less than 1% of cases that people ask the Supreme Court to look at actually get accepted by the Supreme Court. So, how do they decide which ones they're going to choose? Well, they use this informal rule. It means it's not part of the Constitution, it's just a rule the Supreme Court has for itself, which says that if 4 of the judges out of 9 want to listen to a case, then they take the case up. But if less than 4 want to hear a case's arguments, then they just say, nope, we're not going to decide it, and whatever the lower courts decided stands. In order for them to take up the case, it also has to be seen as justiciable. Now, this means, it's a difficult word, I have trouble saying it myself, but justiciable means it's capable of being decided by the court. Political questions are ones of politics and not law, and the court chooses to stay out of political questions for the most part. The person suing also has to have what's called standing. Standing just means that you're allowed to take the case to court because you are the one injured. It also must be a real case, not hypothetical. So it can't be, well, what if this happens? There has to actually be real injury caused. And the person suing must have been the one harmed by the law or the actions of the government. They must then be able to prove that there actually was harm committed. Once the Supreme Court accepts a case, then both sides have to file what they call their briefs with the court. Briefs are very long written arguments that can be hundreds of pages long for the case, laying out the legal reasoning each side believes the court should adopt for their decision. Essentially, there are research papers on each side saying, here's what I think the Constitution means in this situation, and here's past cases that show why you should do it this way. And then the other lawyer provides their own giant research paper that says, no, here's what the Constitution means, here's the past precedent that this decision is based on, and why you should interpret the Constitution this way. Once those briefs are filed, then they have what's called oral arguments. On a specific date, the lawyers from both sides will each be given 30 minutes to make their case with the justices, essentially summarizing their arguments for the judges. Now, the justices are going to read all these briefs, so they're not exactly just there to hear the arguments of the lawyers. Instead, the justices interrupt the lawyers, sometimes multiple times every minute, in order to get a better understanding of their legal arguments. And every time a judge interrupts you, that takes away from your 30 minutes. So you have to be very concise and be very good thinking on your feet and know your arguments inside and out in order to convince these judges that your interpretation of the Constitution is the one that they should adopt. Then, once all the arguments are made, the Supreme Court will debate among themselves in private for several months, arguing with each other about which arguments they like, which arguments they don't, which arguments they should take from the plaintiff, which arguments they should take from the defendant, and then which arguments they have of their own, and then they're going to take all of that and do their own research to see what precedent says while reading the briefs provided by lawyers and by others who just have an opinion on the case. Eventually, they will issue a decision known as the opinion of the court. The opinion of the court can take several forms. The first type is known as the majority opinion. This is a written decision and opinion that the majority of justices signed on to, and this is the only one that counts as precedent for a concept known as stare decisis, which is Latin for means let it stand. Essentially, if they can get to 5 or more judges agreeing to an opinion, that opinion is what future courts should use when making decisions about similar cases. Then there are those who will file what's called a concurring opinion. This is when a justice agrees with the majority opinion, but for different reasons. They say, yes, the court came to the right decision, but they don't agree with why they got to that decision. And that can be important because that means that it's a completely different interpretation of the Constitution. Then there's what's known as the dissenting opinion. The losing side will write their own opinion, hoping to influence future lawyers and justices, and maybe make an argument to Congress on how they can change the law to get past the arguments made by the other justices in the majority opinion. All right, that's the short version of what you need to know about what the Supreme Court does. As always, please end by rewriting today's goal. You can get that at the top of your note sheet, rewind the video at the beginning here, then identify 3 important facts from the notes that help you understand today's goal. And finally, as always, write at least one question you still have that could help you better meet the learning goal. Remember, you can't get full credit without doing these 3 reflections as well. All right, I'll see you when I see you.